Have you been discriminated against at work, or victimized by a credit card company, or swindled by a car lease? Does your case seem open and shut, with strong evidence in your favor? Well, even in these instances, you may not be able to take your case to court. Why not? Because whether you know it or not, you likely signed a forced arbitration agreement when you took the job, got the credit card, or leased the car. Buried in the fine print of most of these contracts is language that bars employees and consumers from taking their cases to court. Instead, these clauses force people into the closed world of private arbitration, where there's no judge, no jury, and the system is rigged in favor of the company. For years, consumer advocates and some press outlets have called for an end to forced arbitration, saying it's an unfair perversion of our justice system. Since 2015, the New York Times has been one of the positive voices rallying against forced arbitration. The Times praised Amazon for allowing customers to sue instead of going through arbitration. The Times also praised Google for ending forced arbitration in employee disputes. Throughout 2021 and 2022, the Times wrote countless articles raising awareness of the move to ban forced arbitration in sex abuse and sexual harassment cases. Last year, the Times denounced arbitration clauses in senior living agreements. And in January of this very year, it went after arbitration clauses at toddler gyms. Given the Times' praiseworthy record on this issue, we were very surprised to learn that the paper of record recently inserted a forced arbitration clause into their own terms of service, their new terms of service, which is the agreement to which its subscribers must consent to receive the paper in digital or in print form. On this issue, the Times seems to have a double standard. They loudly bang the drum for corporations to stop the practice while doing it themselves. As reported in a recent Daily Kos article, the Times updated its terms of service to note that, quote, "Your agreement to arbitration means that for all covered claims, you are giving up your right to file a lawsuit in court and the right to a trial by jury." It stinks of all hypocrisy that's fit to print, in fine print clauses that the paper itself has acknowledged few people read, understand, or have any power to oppose. As the Times said in November of 2015 in their own editorial about forced arbitration, it's happening and it needs to stop. As the Daily Kos article said, perhaps Times executives should reread their own team's coverage and rethink this ill-advised move. It's time for the Times to retract its forced arbitration clause and live up to the paper's own ideals and reporting.